Good afternoon to everyone. On behalf of Acting Director Tracy Troutman at the Bureau of Justice Assistance, I'd like to welcome you to this webinar that spotlights body-worn cameras and training. My name is Tom Woodmansee. I'm a senior advisor at CNA, and prior to joining CNA, I was a police officer for 25 years, and I'm currently involved with several projects around the country, including this body-worn TPA program that's affiliated with this webinar, the Public Safety Partnerships Network that focuses on reducing violence across the country, BJA Smart Policing Initiative, 21st Century Policing Task Force, and the COPS Office Microgrant Program. So this is another presentation in a series of webinars sponsored by the Bureau of Justice Assistance and coordinated by CNA for the Body-Worn Camera Technical Assistance Program. We thank the Bureau of Justice Assistance for its investment in the Body-Worn Camera Grant Program and the Body-Worn Camera Toolkit, and a range of technical assistance resources and opportunities for agencies who are implementing body-worn cameras. BJA supports state, county, local, and tribal law enforcement agencies in many, many ways, and we're grateful that they do. So, as we all know, the implementation of body-worn cameras is complex and should involve other justice stakeholders such as prosecutors and defense attorneys. Some of the more important issues for police agencies as they implement their body-worn camera programs are the sharing and transferring of video footage, while at the same time maintaining a chain of custody, accurate resource planning, and understanding how to best use the footage for screening cases and or charges. This webinar will provide participants with varying approaches to these issues from the perspectives of both prosecutors and defense attorneys. I want to now turn it over to John Markovic from the Bureau of Justice Assistance for his opening remarks. John?
Thanks, Tom. Hi, welcome all. My name is John Markovic, and I'm a Senior Policy Advisor with the Bureau of Justice Assistance, and I manage the Body-Worn Camera Policy and Implementation Program. As many of you know, it's more than just a program to purchase cameras. It's a comprehensive program in which we guide law enforcement agencies through the body-worn camera acquisition and implementation process, including very deliberate and comprehensive development of policy. With 2 funding cycles under our belt, we've awarded approximately $35 million to over 160 law enforcement agencies of various sizes and types. And we expect to award approximately 80 more agencies to be announced in September of 2007 for the body-worn camera policy implementation program. Now, we know that body-worn cameras are growing tremendously, that they've been implemented by and large by many local law enforcement agencies as well as state, tribal, and special jurisdiction agencies. For local and county law enforcement agencies, which are the bulk of agencies across the U.S. and the majority of our grantees, we know there's definitely been a tremendous impact in the agencies themselves, but as Tom alluded to, they have an impact on downstream criminal justice agencies, including the courts, the prosecutors, and the defense bar. These downstream criminal justice agencies, so to speak, may have to deal with a multitude of law enforcement agencies in their jurisdiction. I was just visiting the Chicago area where there are probably 35 to 50 individual law enforcement agencies operating in Cook County. Not only do they have to deal with these multiple agencies, they have to deal with emerging municipal codes and state laws that relate to body-worn cameras or privacy. They have to deal with open data standards, and they have to deal with privacy policies, all of which are very geographically within their jurisdictions and are evolving over time. So our presenters today will give us a snapshot of what is happening in their respective spheres in places that they've worked or that they've consulted in. While there's a bunch of useful information and sage advice they'll provide, you should all be aware that you shouldn't expect a plug-and-play solution. Hopefully your body-worn cameras can be plugged in and played fairly easily, but when you're developing the policy and all the intricacies revolving body-worn cameras, you'll have to adjust your approaches to your individual jurisdictions to their laws, their practices, and the technologies you're using, and then you're going to have to expect to change that as things continue to evolve. So without further ado, I'll turn it back to Tom to introduce the speakers, and thanks for this opportunity.
Thanks very much, John. And I want to echo that I think you're going to find this webinar to be interesting and beneficial. When I was a police officer, I always welcomed the opportunity to hear and learn from the prosecutors and defense attorneys' perspectives. So body-worn cameras are receiving a great deal of attention, and we're finding that there are many layers to them and that they represent far more than just a new technology for policing. So with that, I'd like to now introduce our panelists for today's webinar. Our first presenter will be Christine Hammond. Christine is the Executive Director and founder of Prosecutor Center for Excellence, PCE, and this supports statewide prosecutor-led best practices committees that are devoted to improving the criminal justice system. Christine also provides consulting and research services for prosecutors, presents on prosecutor-related issues from around the country, and is an adjunct professor at Georgetown Law School. From 2013 to 2016, she was a visiting fellow with the Department of Justice Bureau of Justice Assistance, and prior to that, Christine was a career prosecutor in the Manhattan District Attorney's Office in New York City, where she held various supervisory positions. Our second presenter is Damon Mosler. Damon has been a San Diego County Deputy District Attorney for over 24 years and is currently the Chief of the Economic Crimes Division. Mr. Mosler has served as Chief of both the Narcotics Division and Special Operations, as well as a law enforcement liaison for the San Diego County Sheriff's Department. He has taught on a wide range of topics including case preparation, predator and club drugs, informant handling, Fourth Amendment law, and body-worn camera concerns. He is a body-worn camera subject matter expert for the Bureau of Justice Assistance. Our final presenter is Erica Bierma, who is a well-known and highly regarded attorney who regularly appears in the Wisconsin State Courts and the Eastern and Western Districts of Wisconsin. Ms. Bierma's practice includes both criminal and civil litigation, and she has handled and been involved with many high-profile cases. She is a former associate federal defender, where she represented individuals accused of a wide range of serious federal crimes, some of which include white-collar, computer, and tax crimes. Erica has also represented victims of crimes as well as grand jury and John Doe witnesses. I'd also like to add that when I was a detective and Erica was a federal defense attorney in the same district, she was very respected by all local, state, and federal law enforcement agencies. So just a few other comments before we start the webinar. The webinar is recorded for the benefit of others who may view it later on, and you can find it on our website. There will be an opportunity for questions and participation during the webinar, so please make your thoughts and questions known. I can assure you that others will appreciate hearing what you have to say, and if you don't get a chance to voice your comments or questions, please use the chat utility to the right of your screen, and we'll do our best to respond to your input. Please make sure to put your phone on mute by pressing *6 and to unmute pressing #6 if you have any technical difficulties. Just message the host by using the utility to the right of your screen, and we'll help you to the best of our abilities. Following the webinar, you'll receive a request to evaluate it. Please complete the evaluation and give us your honest thoughts and recommendations. We also want you to let us know what other topics you think we should cover on future webinars. So I want to make a special thank you and recognition to Denise Rodriguez and Dominique Curtin at CNA, who do the background work and make these webinars happen and go smoothly. So Christine, let's start. Would you please go ahead and kick us off?
Sure. Thank you very much, Tom. As John mentioned, we are only going to be giving a brief overview of the many complex issues involved in body-worn cameras. As prosecutors, body-worn cameras bring us something that we're always hungering for, which is more evidence and reliable evidence. Examples of the types of evidence that we get is stops, a DWI stop. You will get recordings of an arrest and how that took place. Sometimes you can get recordings of domestic violence victims making a complaint. You could also get a recording of the execution of a search warrant. Sometimes you get recordings of things that is not particularly relevant, but embedded within the body-worn cameras that we receive is this all-important evidence. Could you change the slide? One of the concerns is, do your police departments actually have body-worn cameras. It is not uncommon for prosecutors to be the last people to know that their departments have bought a camera. This is a map of Westchester County in New York that has 43 departments. It is important to know what those 43 departments are, because you hope that you can coordinate them because they are all feeding into the same prosecutor. Next slide, please. The coordination of this has many sort of obvious reasons. It would be helpful if all those departments that report up to or feed their cases up to the same prosecutor have similar types of policies, so they're not inconsistent. It would also be ideal if they had similar types of technology. You'll hear from Damon the challenges that occur when your departments choose different types of technology. That puts a lot of stress on the prosecutor to get different types of technology in order to view and receive those recordings. There are also benefits that the prosecutor can suggest to their departments in terms of procurement. If people get together in a larger group, you may be able to push the prices down. All of these issues can be included in a memorandum of understanding if the police and the prosecutor get involved in this early on. And there are various areas that could go into this memorandum of understanding that I'll explain as we go along. Next slide, please. So the first thing that I had mentioned is police policies. In the past, many departments were buying cameras and did not have policies. Luckily, that's changing. With the help of BJA and their grants, they're requiring policies that have certain elements to them. So more and more departments have policies, and they tend to fall into various categories. The first one is what is mandatory to record. What must the officer record? That tends to be a law enforcement activity when the officer is acting in a law enforcement capacity, such as an arrest, a stop, a search warrant, a parole violation stop. Things like that would be a mandatory recording. Discretionary recordings can go both ways. Number one, discretionary recording can be when an event begins neutrally. It's not a law enforcement event, but something happens that turns it into a law enforcement event. So, for example, the officer is speaking to someone and something happens that results in the officer having to make an arrest. That will now turn from discretionary to mandatory, and the officer should record. But in the reverse, there are certain circumstances where officers are allowed to stop a recording. So, for example, if an officer is speaking to a child sex abuse victim and the child feels uncomfortable being recorded, the officer may decide to turn off that recording because it would thwart the officer's law enforcement purpose of speaking to that victim and finding out what had happened. So it can go both ways. There are often also policies about when an officer may not record. So typically, policies that prevent recording will involve the officer may not record their supervisor or may not record undercover police officers or confidential informants. So that's an example of when they're told not to record. And finally, a police policy should have a basis for deleting, which is the typical example is if an officer inadvertently films when they're in the bathroom, if they should be allowed to delete that. Next slide, please. So the issues that we've heard much about in the public press have been played out somewhat differently in different states, but the one that provides a lot of concern for the public is the use of cameras in what would seem like private circumstances, such as hospital rooms, locker rooms, and bathrooms. My personal belief, and I think this is where most policies are going, is that an officer may film even in those locations that feel private if they're there for a law enforcement purpose. So, for example, if the officer gets a complaint and the victim is in a hospital room, the officer may or has to make an arrest in a hospital room, that they would be allowed to record under those circumstances. The solution to any privacy concerns or any recording that may involve a for example, in a hospital room where you have another patient unrelated to this event, the solution would be to redact that before it's released, to, in other words, erase that part of the recording, and Damon will be speaking more about that. Some states are two-party consent states, where an officer must ask for consent from the party that they're recording. I believe that there's less and less of that as legislatures are allowing officers to record in these circumstances without consent, but there are still some states where that may be the case. The issue that is present in all states is whether the officer should give notice to the person that they are recording that they're wearing a body-worn camera. Most policies are not requiring officers to give notice, but I believe that officers are starting to see that notice can actually be a good law enforcement tool. Sometimes telling a person that you're recording that they are being recorded can calm them down. It can have a civilizing effect. So officers have seen that there are circumstances where they will tell a person, sir, I am recording you, and that is a way to sort of get control of the situation and calm things down. So that has been used as a more tactical device. Finally, it's my strong recommendation that body-worn camera policy should not be legislated, certainly not at this time. This is a quickly evolving area. Every day we seem to learn new issues. The technology is changing. Public perception of cameras are changing. And as we know, legislation does not move and change quickly or easily, and I would certainly recommend staying away from legislating body-worn camera policy because it's such an evolving area. Next slide. So for a prosecutor, one of the most important questions and basic questions is, okay, it's great, we have evidence, but how do we find it and how do we get it? And this is an area that is very good area for prosecutors and police to talk about early on in a body-worn camera program. This is something that would be good for an MOU. And so the prosecutor wants to know from the police which officers are wearing a camera and when. Are they wearing it every shift and things like that. You also want to know, how do I request it? If I want to get a recording, how quickly do I get it? Who do I call? So these are all very practical but very basic questions that need to be resolved so that the prosecutor can get the information in a timely fashion. Next slide. So even if all of those questions are resolved, and assuming we know who wore it and when they wore it, and we get an agreement from the police to give it to us, to the prosecution in a timely fashion, we still need to have a way to identify which snippets of a particular officer's shift pertain to the incident that we're reviewing. So an officer may record during maybe for 2 or 3 hours of an 8-hour shift, and in the course of that have 4 or 5 different incidents. A prosecutor will just be reviewing one of those incidents and has to have a way to identify that little piece of recording that they need regarding that incident. That is being done by something called tagging. And usually the tagging is done by either the officer who's wearing the recording device, which is usually just a patrol officer, and in some instances by the patrol officer's supervisor. The officer will tag the bits of recording that are related to an incident, and they will also tag it as to whether it's evidentiary or non-evidentiary. If something is non-evidentiary, it's just they're driving along, there's nothing on the recording but the windshield of their patrol car, they would mark that as non-evidentiary. If they think it has some relevance to a case, they would mark it as evidentiary. What's interesting about that is, unlike every other type of evidence that prosecutors review, it is the patrol officer who's deciding what is and what is not evidentiary. Normally that's a decision made by prosecutors. So that's something that prosecutors should keep in mind, that the patrol officer may make the wrong decision about that. The reason it's significant, and we'll get to that in a minute, is how long the non-evidentiary tapes are retained. We're hoping that as technology improves, much of this will be automated so that there will be coordination between police dispatch and record management systems and the metadata in the body-worn camera so that it'll be done easily without too much human intervention. But this technology is still evolving. And finally, it's important for a prosecutor to see whether there's an audit trail. Who looked at the recordings? Who downloaded them? Were they tampered in any way? Because there may come a time, and not in every case, but there may come a time when the prosecutor may have to establish chain of custody of these body-worn camera recordings. Next slide. Thank you. So now let's assume we know who had the recording. We know what piece of the recording we want. Now the question is, how do we get it? And that differs. Smaller departments have been sending prosecutors a DVD that they could just put in their folder. But more and more, the prosecutors are getting just a simple link, often through an email, that will link them to a cloud where the camera recording is maintained. My recommendation is that the prosecutor should just get links to the evidentiary portion. You do not want access to the entire body-worn camera database. It's far too big and far more than any prosecutor can possibly view or handle. So next slide. Storage, I mentioned the cloud and DVDs. Smaller departments have, in many instances, just bought their own servers. Those are computer hardware that stores data. And some departments have that, and it's just stored in the police department. And as I said, now it's going more and more to the cloud, and hopefully there are ways of storing it that meets federal compliance requirements. And they're also starting to look at different ways of storing body-worn camera footage so that what you need right now is easily accessible, and things that you may not need so readily, things that may already be closed cases but you want to save, can be compressed and saved in what they call warm or cold storage. These are all things that are being developed and will undoubtedly improve as the body-worn camera programs continue. My personal hope is that states will start to come up with government-controlled clouds so that the evidence is stored and controlled by government. Next slide. So once the prosecutor receives the recording, we assume everything is good news. We've now gotten the recording we've asked for. It's stored properly. Now the question is one of time. When should a prosecutor view this recording? Unlike looking at, if you just take a normal driving while intoxicated case, a prosecutor may be able to review the paperwork in a series of minutes. If 2 or 3 officers respond to a driving while intoxicated case with a body-worn camera, that may generate 2 or 3 hours worth of body-worn footage. So that takes far longer than the few minutes it would take to read their paperwork. And the question that prosecutors have to grapple with is, who is required to look at it? When is it required? For example, must you look at it before you charge? Must you look at it before you turn it over as discovery? Must you look at every single thing before you go to trial? These are questions that have to be resolved. Ideally, the answer to all of those questions is yes. The problem is that there are probably not enough hours in the day for prosecutors to look at everything in every instance. Another question that prosecutors have to start to think about is who can see the body-worn camera footage? Can you show the footage of one police officer to another? Can you show it to a civilian witness, and if so, when? Can you use the recordings when interrogating a suspect? So these are all new things that have not yet been resolved but are worth putting in the back of your mind as the program progresses. Next slide. Another big area that's worth coordinating with the police, because this can become contentious, and it's very beneficial to do it when there are no big issues pending between the police and the prosecutor, is when can the recordings be released? Recordings are owned by the police department. It's their system. So they can release the recordings according to their own rules and needs. That may, in some instances, conflict with what the prosecutor is doing. The prosecutor will tend not to want to release the recordings during the investigative phase, that in the fear that it could influence other witnesses and so forth. Police, on the other hand, may want to release it to quell any disturbance in the community, to appear transparent, and so forth. So that is an issue that the prosecutor and the police should discuss. States differ on whether someone who is actually has been recorded can come in and look at their recording. So that would be another request. Freedom of information requests have also been daunting in their volume and requires coordination between the police and the prosecutor, because certainly they could both get the same request and be doing the same thing if they're not coordinated. And finally, the media is always hungry for recording, so they will be knocking on the prosecutor's door to get as much recording as they possibly can, and this should be thought through in advance so the prosecutor knows what their policy will be and to alert the media as to what their policy would be. Next recording. Finally, this is important, I think. One of maybe the first thing that prosecutors should think about. Body-worn cameras the program was initiated because of a distrust of the police and a concern about police misconduct. And I think people hoped that body-worn cameras would resolve that question. And though I think it does go some distance to do that, we have learned that body-worn cameras don't show everything. They are sometimes not turned down. Sometimes they fall off. And they are not going to be a documentary of a particular event as the community may be hoping for. So I believe that it would be very helpful for prosecutors to meet with community members to explain what body-worn cameras can and cannot do, and also to explain what it means to investigate a case and why the prosecutor may not want to reveal body-worn camera footage, not because they're hiding anything, but because they want to investigate a case objectively and without any tampering of witnesses and so forth. The same thing is necessary when picking a jury for a prosecutor. The juries may hear that there's a body-worn camera and they expect to see clear as bell the entire crime being committed. We know that will not be the case, and it's worth alerting the jury to that fact. And finally, as I mentioned earlier, the media will be constantly knocking on the door to get those recordings, and it's useful to sit down with them and explain the pros and cons of what body-worn cameras can provide. Next slide. And that's it. And I do, for more detail on this, I believe we've handed out a white paper on body-worn camera and prosecution issues. Thank you.
With respect to timelines and workflow, that's one of the most critical things that prosecutors have to think about when they find out that their agencies are getting cameras. About 2/3 of the officers in our county in San Diego have cameras on them currently. And in the next year, we expect that virtually all of the officers in our county will have cameras on them. Last year, that meant over 120,000 videotapes were made available for discovery to both the city attorney's office and the district attorney's office. And that comes from about 2,500 body-worn cameras. We've seen a lot of interesting issues, and we've learned in part what to expect as new agencies come aboard with their cameras. As prosecutors start to see their enforcement partners get cameras, they need to make sure that they communicate with them so that everyone understands critical timelines and workflow needs. Some police agencies may not understand how these tapes need to be made available in a timely manner, more so than other ancillary media discovery. Though viewing all videos before case issuance is not practical, nor is it required in most cases, it is required in some cases. In San Diego, we require body-worn camera-equipped agencies to turn over their videos to us prior to making decisions on assault on officer cases, DUI cases, and domestic violence cases, since it is likely that crucial credibility or visual evidence will be contained on videos associated with these types of cases. There needs to be a mechanism in place to get those videos early for case evaluation, which for cases involving in-custody defendants will require us to make a decision within 48 hours. Other tapes will be needed shortly thereafter, and again, submitting agencies need to be aware and have an agreed-upon mechanism for ensuring that the tapes get to the prosecution team. That means that individual officers will need to label or tag their videos, need to upload them off of the camera, and then have a mechanism to provide them to us, whether it be via a cloud or disk, in a timely fashion. The key takeaway at the beginning is early communication, understanding, and a system for the tapes to get from law enforcement agency to the prosecutors. Next, we have to consider what we will view and what will be required to be redacted. As the videos arrive, each prosecution office is going to have to decide what their viewing policies and plans will be, when and what can and will be viewed, and then by whom. We know you can't view them all at the onset for issuing, but how about before discovery, turning them over to the defense? Will you view all the videos before making them available for the defense? Can you make them all? Can you view them all? And who are you going to have do that? In the city of Phoenix, the city attorney's office there hires paralegals to go ahead and view and redact videos with victim information pursuant to state law. That's something that you need to consider as you make those decisions. For trials, it is safe to assume that a prosecutor will view all tapes before starting a trial as part of their preparation for court. Many prosecutors will want to view with the taping officer that same tape for trial preparation. Time needs to be budgeted for that, both on the law enforcement side and the prosecution side. And then some of these tapes will need to be made ready for court, with either redactions or other editing occurring on part or all of the tape. Redaction is another issue that prosecutors' offices are now going to have to be much more aware of than they are from other surveillance tapes that we've received in the past. And this is going to impact the workload. Will you redact prior to turning over to the defense? Do you have to? What does your law require? If it doesn't require it, are you going to make that decision to redact personal identifying information or confidential information relating to witnesses? Then you have to figure out how you're going to be able to do that. Do you have the software available? Do you have the computers available? And do you have the personnel available to do those redactions for courtroom presentation or for turning over in discovery? In San Diego, we have our deputy district attorneys who are assigned the cases review the videos prior to making them available for discovery, and they do redact some of the personal identifying information that they find on the tapes, which causes them to talk to officers to hopefully encourage them not to include so much information, like holding a driver's license up to a camera or on a clipboard that then we have to redact out. These can be complicated issues, and you need to be ready for, evaluate, and plan for them. The volume of tapes and data is staggering, and we know that all these cases generate way more than one tape. As we turn over to discovery, you have to have plans ready for what is going to go to the defense and how are you going to get it to them. I've made a point in the areas that I work is to communicate with the defense bar to educate them of how the videos are made and how the videos can be turned over to hopefully get them to understand what's occurring and be realistic in terms of the timelines of what they're going to get. It's safe to say that at some point you are going to turn these videos over, and likely you're going to be turning them all over. Are you able to turn them over in phases if you decide to view them? Will that delay cases? Those are things that you need to consider. And certainly we have here in San Diego, we try to watch them all before we turn them over and redact them. But those are big jobs, and some prosecution agencies ask law enforcement to do that. Others feel that they're the ones who know what needs to be redacted, and they do that themselves. And still others use protective orders to prevent the defense from turning over the confidential information to their clients. With respect to discovery, you have to decide when you're going to be providing these tapes so you don't delay your cases and incur the wrath of the bench. Will you do it shortly after issuing, at the same time you turn over your paper reports, or will you do it only when case is confirmed for trial and then turn over all the tapes then? And you need to figure out how you're going to get it to the defense. Will it be via a cloud mechanism or other sharing options that you may have in your particular county? Or will you be burning disks, and potentially thousands of them if you have lots of agencies or lots of police officers with cameras? One other aspect that has been a large concern for discovery here in San Diego is that some videos can be mislabeled, therefore giving them a shorter retention period of time, and they end up being deleted. And then the officer or their agency has to come to court and explain why that tape no longer exists. And that's something that you need to communicate with your officers and have them spot check and try to make sure that they do label and tag these videos correctly in terms of the retention periods. These are clearly important issues to have conversations about and plan with your law enforcement partner and also with the defense bar. If you want to view and redact before furnishing, but you cannot do so in a timely manner, consider making viewing stations available, providing a notice on the complaint indicating that videos are available for viewing at the prosecution office and that you'll turn the rest over once you have the opportunity. That way you're not denying the defense the opportunity to view the tapes. You just don't actually physically furnish them until you've done the redactions. The next thing most prosecution agencies are going to have to be thinking about is that these videos are going to depict things that we normally don't always see. Policing is not always pretty, and if we record all of it, we will see things that are perhaps good, bad, and ugly. Good tapes will have awesome action reflecting the crime on tape and or will have easy to see and hear emotional moving statements by the suspect or the witnesses or your victims. We also know that there will be ugly tapes. They may look pretty bad, but they may be completely by the book police work just in a tough situation that we normally don't see as prosecutors and the court doesn't see. And frankly, some may just be bad with respect to what happens on the law enforcement side, and we can't deny that those will occur. But you need to plan and accept that these videos are coming and how you're going to handle it, and figure out what you're going to do about good, bad, and ugly tapes, and work on your case presentation. I would suggest that for the ugly tapes, the ones that give us a little bit of a heartache, you need to ask your officer, what happened? How did it happen? What were the trial police tactics that were being used in order to be able to establish and elicit good questions and answers from them when they take the stand to show that this was good police work, but things got a little out of control and that's the way it happens. And that way it can be understood and accepted by the jury. You need to slow those things down so you can walk through point by point why these things happened the way it did. And if you understand the tactics, you can ask the proper questions in court so that way the jury can and the court can as well. You can make it come to life and show that what occurred there was actually okay. Finally, for the bad, you need to figure out what you're going to do. Who is going to report it to the law enforcement command? Do you trust young DAs to make those decisions who perhaps don't have life experience to accept that maybe that's not bad, but it's merely ugly or it is good police tactics? How will you evaluate it and what mechanism will you have in place to preserve the understanding and trust of law enforcement when you are, in essence, telling their command about things that you saw that were perhaps not permissible? As you start to head to court, there's other things you have to consider as well. How will you play the tapes and preserve the court record? You need to keep that in mind because in all likelihood, even if you function electronically through a cloud, you're probably going to have to burn a disk in some fashion to create a court record for the appellate court. Before introducing the tapes, do you need to do an eliminate motion? And if so, do you need to be ready to adjust afterwards, in essence, editing or redacting additional video based upon court rulings? What mechanism will you have in place to do that? So shortly before trial. This needs to be planned for and discussed, or create situations where you get to court a little earlier in terms of before the day of trial and have those rulings made since you need time to go ahead and make those videos presentable for court. And what are your local rules or state rules with respect to transcripts? Are they required in all cases in which you introduce video evidence? Will you have those ready? Or can you function by way of stipulation or other agreement with the court and the defense bar to allow videos to be introduced without transcripts? These are some of the issues that we've had over the time here in San Diego and continue to work for making these videos a little less burdensome to the court system. As Christine had mentioned earlier, we have jurors' expectations are clearly an issue. They will expect to see the crime occur on tape like they do on the news or on YouTube. But we know this may not happen. Most likely it will not be caught on the tape by the responding officers. So you need to be ready to have that explained. In essence, have the officers explain reactive policing seldom catches the crime in progress, but rather catches the aftermath. That the camera or equipment and different angles or other scene factors may limit what is and what is not caught on the tape. You have to be thinking ahead of trial preparation so you can have the officer explain and you look open to the jury that you're not hiding anything. Clearly, the best value of these tapes is the fact that it gets to show oftentimes victims for who they really are. In essence, Little Red Riding Hood here, and who the defendant in court is, or the accused, being the big bad wolf. By showing the actual authenticity and credibility of your victim, your witness, and defendant, you get a chance to really paint the picture of what occurred that particular evening. For example, in a recent rape case, the responding officer's report said that the victim was upset. A year later in court, she was composed and cried at times, but was somewhat stoic. The trial prosecutor had viewed the tape before trial and was able to use it. And it showed that when that first officer was talking to the rape victim, she was hysterical. She could barely talk. The tape showed how horrible the event had been. The jury and the judge were riveted and emotional like she was. This was a fantastic way to show the true impact to the trier of fact. And who has not had a case where the defendant in court looks like a choir boy in trial, all cleaned up, with yes ma'am and no sirs, but at rest he is cussing, spitting, and looking scary. You have to think about ways of how you're going to get that in and get the true view to the court and to the jury to see what's really occurred. I think it's important to make sure that you find a way to play some tape somehow, since they do exist and jurors will want to see your victims and witness and certainly your defendant back close to the time of events, even if it's not all caught on tape in terms of the crime. Also consider, whenever possible, using empathetic moments by officers. Find ways to use them to be able to humanize your officers and show what good police work they are doing out there. And finally, each one of these cases that you present and prepare are training opportunities for the officers. As a prosecutor, you need to look at these moments as teaching moments. As you do trial prep, you can show the officers things that you see on the tape from your prosecution perspective and how maybe they will think a little differently when they're in the field and able to capture certain evidence on tape. Whether they can do narration if the crime permits it in terms of responding to a case, saying what they know about the case, or they do a scene walkthrough, recapping what occurred on videotape, so it all comes to clear for all of us when we get a chance to see that. And finally, defense attorneys, every time they ask questions or present a theory of the case involving the cameras, pay attention to that and alert your officers. The defense attorneys do pick apart things. That helps train our officers to focus and maybe do a better job. So look at those as opportunities. And with that, I will turn it over to Erica.
Thank you, Damon. Well, I will start from the perspective of the defense attorney, and I just kind of want to explain what our current usage is in my neck of the woods. I'm in Wisconsin, and I can tell you that our largest metropolitan police department does not have body-worn cameras yet, but a lot of our smaller municipalities and outlying jurisdictions do. So I'm speaking from the vantage point of a smaller department versus what Christine and Damon are talking about. From the defense perspective, the first contacts that they're having with body-worn camera is the policy, what the activation or not activation of the body-worn camera. Some departments, I have seen policies that require always on, which means that the camera is recording every interaction that the officer has during an entire shift. Where the issue arises from the defense perspective is when there's an on-off policy. And that can be specifically delineated in the department policy. However, obviously there will be questions about in the stress of a situation or in the event of technology malfunction or for whatever reason that the footage of the incident was not recorded. And the defense is going to raise multiple issues about why that specific interaction was not recorded. So that will be, as a starting point, starting from the policy where the defense will be starting to look for perspectives and areas to explore in cross-examination. And from the defense perspective, I disagree with prosecution and prosecutor identification of the incident or the officer identifying what is evidentiary or non-evidentiary. And why I say that is because at the time that the case is being charged, the defense doesn't necessarily know what their theory of defense is going to be at that time. So something that the prosecutor or the officer may think that has no evidentiary value when in reality it may be pertinent to the defense. So I don't like, and what can be done about this we don't know yet, because obviously there will be a lot of litigation over these types of issues as to an officer determining what's evidentiary or non-evidentiary related to the incident, or the prosecutor identifying the benchmarks of the incident, of where the alleged incident started and where the benchmark is of where the alleged incident ended. So that's going to be a huge area for litigation from the defense perspective, but it's also who's identifying what the footage is and tagging it as relevant, evidentiary, not relevant, for purposes of retention periods. The other question is going to be, again, for juries and for the defense, if the technology fails, if there isn't a recording, why isn't there? And I mean, with juries, they obviously want everything to be like NCIC or NCIS or Law and Order. I mean, that's their expectation nowadays, so we all have to manage their expectations. The other thing that the defense will probably want to litigate extensively is who's reviewing the footage prior to the disclosure to the defense. This arises with the trails of who's looked at it, when, for what purpose. First and foremost, the police officers should still write very, very detailed reports, separate and apart from hoping that the footage will take care of everything, show everything, and they don't need to worry about what the reports look like anymore. Because I can tell you that in the stress of a situation, there are times when the recollection of the officer is different than the way that the report was written, but it's imperative that the reports have quality writing, detailed, and just because there is body-worn camera footage, that the reports don't fall by the wayside. The other issue for the defense, another issue for the defense, is who has access to the specific footage. Like Damon enumerated, that sometimes the prosecutors want to review the footage before they provide it to the defense, and when. And I can tell you from the defense perspective, not just for evidentiary purposes, but the sooner that the body-worn camera footage can be disclosed to the defense, that can also help the defense manage the expectations of the client, in the sense that if you have body-worn camera footage that shows them committing the crime red-handed, perhaps plea negotiations or resolving the case short of a trial may occur sooner. So I would suggest that there isn't a delay in providing the body-worn camera footage to the defense, but also there will be a lot of litigation about redaction and personally identifiable information of witnesses, victims, that kind of thing, because the defense is going to want to know who, what, when, where, why, who was interviewed related to this entire situation. But then the other question is going to be, in what special circumstances, what happens when there's an officer-involved shooting or an officer-involved death? When and who gets to review the footage? Another big issue in Wisconsin is the records retention. Wisconsin has not legislated yet what category body-worn footage occurs under. Right now, it seems to be interpreted under our open records law. However, there are periods of retention for evidentiary footage versus non-evidentiary footage, and if the individual officer or prosecutor is making that determination that something is non-evidentiary, when in reality it may be evidentiary to the defense because they don't know what the defense theory is at the point of time that they're determining what's evidentiary, the footage could get destroyed by the time it would be disclosed to the defense, which is going to require explanation to a jury and obviously subject to significant cross-examination. The other one is with the departmental on-off policy, how long is that footage maintained? So if the defense wants to do an open records request to see if there's additional footage related to that incident or from another officer or from a superior that hasn't been disclosed yet, is there some other way to get that, or was it marked as non-evidentiary by someone earlier on in the process and then it no longer exists? Another main area for litigation for the defense is, again, the inconsistency between the footage and the recollection. The body-worn camera footage will not necessarily show everything. I can tell you that the body-worn camera footage that I have seen, sometimes you can't even see what the actual interaction is, because if the officer happens to be smaller in stature than the person that they're interacting with, all you can see is from the person's bottom of their chin until about mid-chest. So you can't see the person's face, you can't see their arms, you can't see their hands, you can't see what's going on outside the frame of the camera. So the body-worn camera footage may not be the end-all, be-all in the favor of all charges and prosecutions. The other issue is the vantage point. Depending on where the officer is standing in relation to the person they're interacting with dictates how much can be seen from the body-worn camera footage. The other big issue is in foot pursuits. I can tell you that it is very difficult to hear anything. I can hear the breathing of the officer, the footfall of the officer, the jangling of everything that is on the officer's belt, but it is extremely difficult, one, because the camera is bouncing, but to hear any commands or response by anybody. So for court proceedings, that may be a lot of area for cross-examination as well, because it's very difficult to hear anything if the officer happens to be in a foot pursuit. My main takeaway from this is that there will be lots of litigation over the next several years, even if statutes are changed, if states clarify as to what statutes, if it's open records or records retention policies that fall, where the footage falls in those laws. But the defense is probably going to file lots of motions and lots of discovery demands trying to figure out who, what, when, where, why things were retained, why other things weren't, why were things determined to be evidentiary and other things were determined to be non-evidentiary. And for those reasons, that's why report writing still is crucial. But also, I would say that for purposes of negotiation, it's in the prosecution's and the individual agency's best interest to provide the footage sooner than later, because that way I can use it, I can go to my client, show them the footage and say, this is part of the state's evidence. You know, this is very difficult to overcome, so what do you want to do in light of this footage? The only other thing that I would mention is that there will probably be a lot of litigation over right to privacy issues, specifically in the realm of, let's say, an operating while intoxicated. If my client was in an accident and was in the hospital receiving medical advice based on the injury associated with an operating while intoxicated, I would not want an officer recording that information to be marked as non-evidentiary later when my client has a reasonable expectation of privacy in medical information. The other thing is where individuals have reasonable expectations of privacy specifically like their homes, and it did not start as a law enforcement event. And so I would not want that recorded to have someone determine later it's non-evidentiary, but it's still maintained in the database. But I think that this is a very interesting area, and it will create lots of litigation, and there are still lots and lots of issues that have to be worked through policies, implementation, and then in the courts. Back to you, Tom.
Great, thank you, Erica, Damon, and Christine. Some really interesting information. We appreciate your expertise and insights. So we've had a few questions come in. We won't have time to address all of them, but we want to talk about a couple, so I'll throw them to the panel. First question is, will there be a countywide plan or plans in place to permit flagging for retention in criminal cases? So I'll throw that up to the prosecutors, I believe. Makes most sense.
You know, Tom, I think a lot of that's going to depend upon the relationships within a given county. Some counties, the various agencies get along very well, and they have a system in place where they already do joint training and other communication. And quite frankly, there are counties that does not occur. But I think that certainly is something that is worth pursuing.
Great, thanks, Damon. Christine, do you have any input on that at all?
No, I agree with Damon completely. It's an ideal, and I think that's all parties should strive for, and it would be even nicer if it was statewide, but that's going to take some time and a lot of discussion.
Great, thank you. So let's go on to another question. You talked about some of the limitations and even jury expectations. Will prosecutors and/or defense use expert witnesses on body-worn camera to educate the court, the jury, and the juries about the limitations of body-worn cameras? Start off, Christine. How about we start with you?
I expect that that's going to be the case in many different ways. I'm sure they're going to talk about what the policies are to turn them on, what the range of view. So, for example, how far can the camera see right to left? What is the expectations of how it can it see at night? I mean, there are going to be many things that it might be worthwhile bringing in an expert.
Excellent. Damon, any additional?
I see it in a large part on either use of force or officer-involved shooting cases where things happen so fast that even with a camera, the camera's not always picking up what happens at the speed of light, given frame rates and things like that. And I do think that experts could be useful there for pre-charging decisions or presentations to the court.
Thank you. Erica, anything from the defense perspective on that?
I think it would depend on the specific case because obviously I don't bear the burden of proof. So if there's something specific in dispute, possibly, but otherwise I would say that that's going to be more on the prosecution's burden than me.
Understood. That makes sense. Final question, I think, goes to the additional need for follow-up potentially. Are you finding that body-worn camera footage creates an additional requirement for follow-up requests on behalf of the police officers or agencies on case investigations? Damon, you want to start?
Sure. Not that much, to be honest. The only time I've seen that happen is when there are other people at the scene that we haven't identified that will want to go out and find them that weren't interviewed. But otherwise, the scene is static and captured, and the videotape kind of speaks for itself that way. We haven't seen additional work for law enforcement as a result of that.
Okay. Chris or Erica, anything on that?
Well, prosecutors always like to ask for more investigation, so body-worn cameras or not, they're always going to be asking.
Yes, absolutely. I can attest to that. And
yeah.
How about Erica from your defense side, as far as like your defense investigators? Do you foresee that?
Well, I was going to say, I mean, with defense investigators, it's entirely possible, but they're not going to have the advantage of law enforcement who knows who the person is or is able to identify the person. So they're going to be kind of starting from scratch and trying to figure out who the other people are that might be in the frame of the camera.
Great. Great. Very good. Okay, we're running short on time, so I think we're right on time, actually, but I want to wrap up before I turn it over to John and just thank the presenters. I thought it was fantastic, and our goal for the webinar was to provide you with some helpful information and insights on the importance of the dynamics of body-worn camera relating to prosecutors and defense perspectives. We hope that you found it helpful. And I think from my perspective, most citizens likely view body-worn camera as just a new technology for police, but I believe we all know that it's far more than this when it comes to the considerations that we have to take in place with the community impacts, the community expectations, and it makes it even more critical that we understand the complexities, limitations, investments that come with implementing and sustaining your body-worn camera programs, especially the importance of understanding the perspectives of your prosecutors and defense attorneys. So with that, I want to thank BJA and John Markovic for making this webinar possible. So John, I'll turn it over to you for any closing comments. Thank you.
Thanks, Tom. Well, first of all, I want to thank the speakers, Christine, Damon, and Erica, for their insights and valuable information, and certainly thank CNA, particularly Dominique and Tom today, for putting together another well-executed and informative webinar. I think we've learned a lot about how body-worn cameras affect not only law enforcement agencies, but other criminal justice actors and the judicial process overall. I think we've been given some great grounded advice. Tom, I think you hit the nail on the head when you said it's a dynamic field, just this morning, I was reading some articles, and I've been following articles on the changes in technology. More and more body-worn camera vendors are integrating or promising to integrate facial recognition. That may change the generally good public acceptance of body-worn cameras as tools for transparency and accountability into concerns regarding surveillance. And that again underlines the importance of good policy and good assurances for assuring compliance with policy. And then, as I think it was Christine alluded to, and also Erica, there'll be lots of new case law. I think that'll be coming about as body-worn cameras exist now and as their technology evolves. So thanks again, and keep tuned. I think I'm turning it over to Dominique to make a few closing comments about resources.
Thank you. I just want to remind everybody that we have an evaluation after this webinar that will pop up. Please let us know your thoughts and any feedback that you may have, as well as topics that you'd like to learn more about. This webinar will be posted on our website in just a few days with all the content that was mentioned today. For more information, you can visit our website at www.bwctta.com or email us for more information. So I want to thank everybody, our panelists and our attendees, for joining us today. Have a great day.